Good evening. Hello. I've just taken part in I've just really listened to a discussion about the two insulin cases, baby F and baby L, in the Lucy Letby case, the two insulin cases. It was very interesting. A lot of good points were made, and some that I was aware that people were talking about it in this way. That one of the fundamental things that people have been discussing for a long time is that the test results that were used in the trial were not the appropriate tests. What were done and these results that led to the verdicts of guilty in the cases of, the whole jury voted guilty, and they were the first verdicts that came back for baby F and L for attempted murder, because they didn't die, these babies. That the tests were done, they're called immunoassay tests, and the challenge to them is that they're not the appropriate tests that were done. That even in the documentation from the laboratory that did these immunoassay tests, it states in their own documentation from the laboratory that if you suspect exogenous, i.e. externally given, artificially created insulin, exogenous insulin, different names for the same thing, then you need to use something called a mass spectrometry test. And there's also an adjacent test to that, which apparently is called tandem mass spectrometry. I think the full title for the mass spectrometry is liquid chromatography mass spectrometry. And this type of testing, which wasn't done, is able to test for very specifically whether external or exogenous or external insulin has been given, i.e. made by a manufacturer and given to a patient, in this case the very small babies. And not only is it that this spectrometry tests the essential tests to use in order to establish that exogenous insulin is there, rather than pro-insulin, rather than insulin that's been created from the body of the child or adult, if it happened to be an adult themselves. This type of spectrometry test would actually be able to show the brand of exogenous insulin that had been given, because each different brand has its own brand markers in terms of how the strings of molecules that make up the insulin. There's certain ones that have been missing. They're not integral to its effectiveness, but certain ones are taken out in order to create a kind of fingerprint for a particular brand, and each one has a slightly different combination of ones that are missed out in this string of molecules. But they're all insulin, but they're different brands, and so they're able to establish which brand it would have been with these tests. So that's a bit of the background, and that's come up before in previous videos. We've been talking about that for a long time, that it was unfair this evidence should have been thrown out. It shouldn't have been allowed because the tests were incorrect, and even though the prosecution experts said that they were okay. So this is where you had, I think it was Dr. Milan, who said that it was just advisory that you had these, if you were testing for exogenous insulin, that you would use the mass spectrometry. Just advisory, even though on their own literature it says that that's what you ought to do. So they're just kind of having their cake and eating it, really. They're just kind of evading the necessity to do the proper tests. But from a legal point of view, and we're back to that thing now, and I know this is old ground, is that for some reason, the defence acknowledged it as an accepted fact that exogenous insulin was added to these TPN bags in the cases of babies F and L, and it shouldn't have been, i.e. the bags, the TPN bags, these feeding bags, where insulin was given to them. It shouldn't have been, and it was done by a particular person, for malicious reasons, i.e. Lucy Letby. And they accepted that as an accepted fact, but they didn't accept that Lucy did it. They accept somebody had done it. Somebody's done it. Somebody's done this malicious act. And it was a terrible thing to do. It was a disaster to do that. I don't understand why. I don't think anyone's explained to anyone why they had to accept that, particularly when they could challenge the nature of these tests, that they're not the correct tests. So they should have challenged that evidence being put forward as a whole, really. Perhaps they did. Perhaps the judge just said, no, it stands. And it put them in a situation where they said, well, we've got the only move we've got left to do is to say, okay, well, we accept somebody did it, but it wasn't Lucy. But that's never going to work, because you've got, I don't know, dozen or so or more other cases of all these other intended harms and murders and attempted murders that are all being laid at Lucy's door by overfeeding, injection of air, trauma of different kinds. So the idea that the jury are going to say, well, oh yeah, perhaps it was someone else doing the deliberate harm through the insulin. Lucy didn't do those, but she did all the other ones. That was never going to work. It was a disaster. It was cutting your own throat, really. So something really awful happened there. I didn't get a chance to ask a question at this. I was too busy listening, but what a question was in my mind as to whether the blood samples or the blood plasma samples that were sent to the laboratory by whoever ordered it, and that's a thing that came up in the meeting. Who ordered those samples to be sent to the laboratory, and why, and when? As somebody said, was it a locum who never followed it through? Why didn't they follow it through? Because just to remind you that these test results that became the very convenient quote-unquote smoking gun, quoted by Evans and others subsequently, Dowie Evans said that these are the smoking gun cases. Those test results were only kind of discovered by Dr. Breary in 2018. So what they had up to then is the 32 cases of deaths, of notes that were sent related to serious crashes in health and deaths across 2015 and 16 that had been sent to Dowie Evans by July 2017, and took a further year for Breary to find the smoking gun, to consolidate these other ones, to hang, to get all the other ones over the line. That's how it's described. That's effectively how it's described by Evans in the post-trial interviews and by other people, that these were the now we could, from memory now, he says something like, Evans says something like, now we could finally prove it. You can infer from that up to that point they couldn't prove it, i.e. all the murders they couldn't prove, all the situation where there were health crashes which were documented in some form or other as health crashes, as crashes, sudden deteriorations in health, which had been sent in sets of notes to Evans in 2017. None of them could be proved until you got the smoking gun cases. And here's the bitter, it's not an irony, it's a kind of tortuous torsion of this situation. Until you got, in 2017, Breary, for some reason, is looking through notes and finds these very high readings, allegedly, and finds them. And they're about two babies who didn't die, thank goodness, but also didn't have a sudden deterioration in health which would warrant the police and initially the hospital sending documents to the police to go on to Evans back in 2016, i.e. nothing happened during the stay of those babies, their stay in that unit, which warranted any suspicion of a sudden deterioration of health. And yet those are the two cases which became attempted murder cases, and were found guilty, all the jurors said guilty. They were the only cases where it was 11 jurors, because one had been let go. The whole jury voted it, and they were the first one to be returned as well, the verdicts. So you've got a situation where all the murders are hanging on, and all the ones where you've got an observable deterioration and crash in a baby's health are hanging on two cases in which there is no recorded or ascertained crash in the baby's health, let alone the baby nearly dying or dying. What's the realisation I've had in recent days, and I don't remember exactly how it happened, but it was just this sudden awareness that I'm going to try to put this is bizarre, this actually. So you've got this scenario where all these murders, all these cases, all these attempted murders and murders hang on two cases, on the two so-called insulin cases. But it's not just that way round. It's not just that way round. You've got this, and this is the tortuous knot of it all, and the absolutely, it should be absolutely unbelievable how this has come to pass, is that the two insulin cases, which become the smoking gun to pull all the other ones over the line, and the inference there is that none of those would have even got to trial. None of them would have got to trial, or they would have collapsed, because there's no hard evidence at all. And there's no evidence in the insulin ones anyway. We'll put that to one side. The insulin ones pull all the other ones over the line. But here's the kicker. The insulin ones wouldn't have got over on the line themselves. They wouldn't have. If they were the only ones that had been brought to the notice of the police, they wouldn't have come to trial even. They wouldn't have even been found. They wouldn't have been found because those babies, yes, there was a blip in their insulin levels and their glucose levels, but it wasn't even noted to the level to the point where it was deemed a serious deterioration in health. So you've got a situation where the smoking gun carries all the other ones over the line, and yet the smoking gun couldn't have done it on its own. The smoking gun needs all the other ones. I hope I'm making this clear, because it's just screwing with my mind, the bizarreness of this, how dependent they are on each other. You've got one set of all the murders and all the attempted murders over here, all the rest of them wouldn't have made it without the two insulin cases. The smoking gun, which they keep telling us, it was, Evans says, that now we can finally prove it, therefore you couldn't prove it without them. And yet, the smoking gun on its own wouldn't have got to trial. How bizarre is that? How absolutely twisted and bizarre and weird is that? You can see again another angle on the construction, of the fake construction, of the finesse, as I keep calling it, the dark finesse of making this thing just all hang together out of individually unworkable pieces. But weirdly, with the corrupt police, the corrupt judicial system, the corrupt Evans so-called experts, the corrupt other experts that are speaking out of the area of their expertise and just trying to move past any challenges to what they're saying because they're being paid by the prosecution. The whole corrupt system, somehow you bolt these two ineffectual pieces together, and then you get somebody for 7 murders and however many attempted murders there were. I know it, but I can't remember it all off the top of my head. I can't keep it all in my head at the same time. But one of the questions I would have asked in the meeting that I was just a part of is that are the blood samples or blood plasma samples, whichever one it was, or both, that were sent to the laboratory, which ended up with an immunoassay test for baby's FNL, which produced these massive readings, well, way more than the other. Were the other samples been destroyed by means of the testing? Or are they somewhere, or do they still exist? I mean, if they don't exist, should they exist? Were they thrown away? Were they destroyed, or not destroyed so much, but were they used in the test in order to do the immunoassay test? Therefore, you can't access it again. It's a one-shot thing. And those babies, well, there's no point in giving them a blood test now. Obviously, they're young children now, and it's not relevant now. It would have been only relevant to the situation they were in then, when they were having these TPN bags, So it led me to thinking that if it's a case that, well, first of all, I want to establish, are there any samples? Have they kept any? The likelihood is no. But if the likelihood is no, or if the actuality is no, they haven't got these samples, why can't it be a legal argument from the defence at the appeal now, and should have been at the original trial, to say, we're not buying, and we can tell you what, we can show you the Professor Mark saying, and lots of other authorities saying, you can't just rely on immunoassay tests for exogenous insulin. It's not sufficient. It's not reliable. And this is the defence speaking. Should be speaking to the judge and challenging that evidence should never get before the jury. In which case the smoking gun's out of the court case then, which I think everything else collapses. Defence should have gone to the judge and said, we're not accepting the immunoassay test just on their own. It should have been the mass spectrometry. It's a hard word to say. Mass spectrometry tests, the liquid chromatography, and even the tandem mass spectrometry tests, in order to fully establish, to be very, very confident that it was the result of exogenous insulin rather than insulin from the baby's own system. Because you could have, as I said before, you could have even worked out, if it was externally given insulin, worked out even what brand it was. That we're just not going to, we can't. It's not fair, because we can't. And if that blood can't be retested, if it wasn't kept in that laboratory or it was used up by the process of testing, it puts our client Lucy at such a terrible disadvantage that we've been presented, and the jury will be presented with a complete fait accompli that can't be challenged, can't be fairly challenged. In other words, the basis of the argument here is that you're getting away with being able to convince a jury that this should be scientifically believed, when there's a very, very strong argument against its potential veracity and its reliability, and we're not allowed to, and we're not able to do our own tests on it, to challenge it. So how fair is it? How prejudicial actually is that evidence to have it there at all? And why wouldn't a judge? Why didn't the judge agree? I mean, I don't know where those arguments were made, but had they been made, why wouldn't the judge say, well, yeah, you're right, you can't, you're making a valid criticism of the potential unreliability of those immunoassay tests, and you've got arguments to back that up. So therefore, it would be prejudicial to show that evidence to a jury when you haven't got the opportunity to get the blood of that baby, as was then, retest it with the mass spectrometry, and to make double sure. Or to make sure at all, actually, not double sure, because it would actually give you the actual proper information from there. So all you're left with, it's just a piece of paper, isn't it? It's just a bit of paper in the medical notes as what's damned Lucy. Acted as the smoking gun, pulled all the alleged, well, not, I mean, she's been convicted of it, but all the trauma, all the air embolism cases, all the overfeeding cases, pulls it, the 2 insulin cases, pulls them all along in their wake. But they individually and on their own would never have got to trial, would never have gone over the finishing line. But even more than that, they would never have even been found. There would never have even been an issue to be brought up, ever. I mean, that's what I just want to get across, is that the scenario is, had none of the other deaths been looked into in any way whatsoever, and there hadn't been the chain reaction of getting the police involved or Evans involved or anyone else, and then nothing had happened with any of those other deaths in 2015 and 2016. No focus on Lucy for anything, no focus on anyone. What happened in the stay of those two babies, F and L, that nobody would have ever looked at those notes ever again. Never thought about them ever again. I just want to repeat that the stay of those two babies, F and L, in that hospital was so undramatic, clearly, because those babies' notes weren't passed on to Evans in 2017 because they weren't even deemed to have crashed or any sudden deterioration in health. So there we are. So that's what I would want to see at an appeal, is for the defence to say, well, if we're going to do this again, you're not going to have your smoking gun. We can't have your smoking gun because it's not fair, because the tests were, and these are the arguments we're using, why they weren't sufficient, why they weren't reliable. These are the tests that were reliable. The samples have now gone, which means it's impossible for us to fairly contend with the unreliable results of the immunoassay. And as somebody made a point in the meeting, who knows how well the samples were treated at the hospital, where they got the samples from, which did they get them from certain ports on the baby where the baby was having certain drips put in and so forth. Could there be some contamination from what was coming through the drip? Were they properly dealt with at the laboratory itself? Did they go through all the right procedure? How do we know? It's all on trust, isn't it? They just say, oh, we did it all right. That was the results. They're not going to say, oh no, we probably balls that up, because because in one of the cases, I can't remember if it's baby F or L, but it's one of them. There's a level of alleged insulin level in there that other people have said, and a number of people have said it, that would have put a fully grown adult in a coma or killed them, and yet the baby went home a few days later. If that is the case, and if that's provable, why isn't that a further legal argument that would be brought to bear? Maybe it is. Maybe they have done that, and if they haven't, why wouldn't they do it? And why wouldn't they do it at the full appeal, to say that if that is the case? And I just don't understand that if people are asserting that, then can they be so wildly wrong? If they're asserting that level of insulin, because it's an area that's been studied for decades and decades, isn't it? That if you've got a reading that high, if people are asserting it very, very confidently, it would put an adult into a coma, and yet the baby survived it, a tiny little premature baby survived it, without even having any kind of sudden crash or deterioration in health. If that can be confidently asserted and it didn't happen, it's got to point towards a false reading. It's got to point towards something going wrong when the blood was taken in the hospital, or part of the process in the laboratory. I don't want to say too much about details about the meeting because it was a private meeting, but what's come up, and other people have been talking about it on Twitter as well, is this concept of something called the hook effect. It's a bit complicated for me, but the basic idea that I get from it, and that, as was described, is that you can get readings of certain chemical reactions that are going up and up and up and up and up, and you keep expecting them to go up, but there can be a sudden drop in them, so you can get a sort of false reading, or I think I've got that right. I think I've understood that right. I've looked it up on Wikipedia, and it's a bit complicated for me to understand, but the long and the short of it is that what they've told us is, from the baby's FNL, is that it's exogenous insulin as a result of the immunoassays because you've got this high insulin and the low C-peptide result. Is it possible that this strange or unusual, or I don't know if it's strange or unusual, but this tendency that you can get the appearance of a very low reading when it's not actually a low reading, that's the upshot of it, that you get a low reading of a certain thing, and it could be the C-peptide, i.e. was that reading artificially low because of this thing called the Hooke effect. You can have a look at it. I'll put a link to the Hooke effect underneath and a link to the mass spectrometry as well, but it's just something you can look up anyway, but something that a lot of people are talking about. Other people are doing work on other aspects of this to do with the insulin cases, but the thing that just blew my mind really, it's got, and maybe loads of other people have thought this already, it's not that but it was new to me, the idea how much the smoking gun is relying on all the how much the smoking gun of the two insulin cases is relying on all the other cases that it's meant to be pulling along and making valid and pulling over the line. The smoking gun should be something that would... The smoking gun, should it not, be something that if it was just that in isolation, that would be prosecutable and somebody would be able to be found guilty of it. But we've got a situation where the smoking gun, the strongest bit, the strongest bit that pulls everything else with it in its wake, if it was just the smoking gun, it would get nowhere. Does that make any sense? Does that make any sense? You've got two elements just weirdly jammed together, supporting each other mutually, and yet separately would go nowhere. The second part of it, I'm repeating myself now, so I'll shut up in a minute. The smoking gun would not have even been established or found or looked for even. Not even looked for, not even suspected. It took over a year because, Evans has had those notes since May, June, July 2017. They needed more, which is why you've got this series of arrests over 2018, 19, 21. They're building it up. It's taking years and years to get it because it's not easy to pull any of this stuff over the line on its own. It needs a concoction. It needs what I was talking about, the finesse. It needs this construction to happen. It's hideous, all of it. It's hideous. It's so bad, it shouldn't be possible. It shouldn't be possible. But it is, and it's happened, and it's got to be put right. Anyway, madness, I tell you, madness.